Let's talk about this idea in general, though, the idea that someone else did these homicides, or multiple people did these homicides. Maybe not.
Mike, I want to go right to you. What does Ann Taylor have to present that makes Judge Hippler allow her to do a presentation on June 21st and presenting this alternate perpetrator theory, Mike?
Yeah, Bill, she's got a foundation she's got to build. You can come up with a name. I could say Bill Cannon was a person who was one of the 1,000 people whose name was given to the police as an alternative suspect. Okay, we're not going to allow you to, Ann Taylor, to just announce that in front of a jury. You tell us now, and I'm Judge Hippler. You tell me now. You've got a name, okay? What evidence do you have that your own investigator in your own office is turned over to you, showing that he was in Idaho at the time? He was in Moscow, Idaho. He's got some sort of motive. He's got some sort of weapon. That sort of thing. You have to have a foundation of evidence that would actually be admissible. I just can't say Bill Cannon is an alternative suspect. And because it's been known in the community that he had a violent past and he takes drugs. No. That's that's not enough of a solid foundation that you could bring this information in through an investigator, and it won't be like triple hearsay, nonsensical stuff, rumors. No, if you're going to call somebody out and claim that they are a suspect, you better have evidence to show me that would be admissible in a court of law, not just rumors and smoke and mirrors. So that's
Mike,
what Judge Hippler is saying.
Mike, I used to say on the street, and when I would teach even in college or teach to young cops, I used to call it the ladder of suspicion. And as we always know, to stop someone on the street, mere suspicion isn't good enough to stop and frisk someone. You need what's called reasonable suspicion. And you have to be able to articulate. And then the third rung of the ladder of suspicion is probable cause. And that's the arrest phase. And that after reasonable suspicion, where an officer is allowed to stop, question, and frisk an alleged perpetrator, probable cause is the stage that you can put handcuffs on someone and take away their freedom. They are under arrest. Now, in this case, and the reason I'm sort of comparing or using this analogy is that the judge has to have some really, reasonable suspicion that what Ann Taylor is presenting is credible and not just bullshit. Oh, right. Show me evidence. Phil, I could see you want to come in.
Yeah. No, I think the word reasonable is really what we have to drill down on here. Now, listen, in a defense, there's always going to be the defense instinct to try and point the finger at someone else. So now if Ann Taylor brings in someone that, let's say there was an unprovoked attack, some type of an assault, something with a knife. Okay, it happened in the area. Maybe that name was thrown into the tips line and they investigated. But what else is there other than a person who may have been previously arrested for a knife attack or something of that nature, or an unprovoked attack? What else is there that brings that person into the circle of these four murders? And I think that that's what the judge is looking for. He wants something reasonable that if they say, well, we believe that this person is there, he had been in the house. If there's a lot of other things, then perhaps maybe he could allow them to say there is an alternate suspect. But I think she's going to have a really, really strong argument for the judge to rule in that direction. So again, the word reasonable, I think, is very, very key here. It has to be something reasonable. You can't just say,
Phil, is there physical evidence? Was his car seen in that area?
Exactly.
Does he have cell phone pings in that area? Or else, if she doesn't have evidence like that, if I was the judge, I'd say, you got to be kidding me.
Yeah, it could be someone that delivered a pizza there one time. That's not going to be strong enough. You know what I mean? All right, that person might have a history and arrest for an assault, but that doesn't mean anything. I think, Bill, you just brought out the point. All of the other things, the fact that the vehicle was seen there on video, the fact that he shut off his cell phone, the fact that 23 times his cell phone was pinging near or close to the location. That's all reasonable stuff that's going to be put forward that would indicate that Bryan Kohberger is, besides the DNA evidence, obviously, that Bryan Kohberger is the person that committed these horrific 4 murders. So the alternate suspect being brought in, it's going to be very, very stringently looked at by the judge. And let's see what his ruling is going to be. In my opinion, I don't think there's going to be a good ruling in favor of the defense here.
No, you know, Kathy's indie zone. I love this, Kathy. Reasonable is key, as Phil correctly states. I love the word reasonable because as we go through life, we meet many people who are not reasonable, you know, not a reasonable person. And the language in the standard of proof called probable cause is as far facts and circumstances that would allow a reasonable person to believe that a crime has been committed and the person being arrested committed that crime. There you have the word reasonable. And I'm sure we have an attorney here, Mike Geary. He could define the word reasonable in a legal sense even better than I just did.
Just a prudent person, using their common sense. Was a crime committed? Will it be committed? Like, for instance, an attempt. And is the person that you see, that's the person that you believe, that you reasonably believe is the person. So therefore, you know, she's got a mountain to climb in order to create a foundation. And I will say this one thing: if we didn't have that kind of requirement in a courtroom in America, then any person could be accused of some sort of vicious crime by a defense attorney in order to get the focus away from their client. And if they did that, she just blurted out somebody else's name in violation of, if Hippler says you can't do it, that's defaming someone. And that person could sue Ann Taylor for doing that. How dare you accuse me of a quadruple murder? You have no proof of that. That's why it's such an important point, because we don't want her to defame somebody in desperation in order to try to secure Kohberger's acquittal at the expense of an individual who has absolutely nothing to do with this case.
Jack Johnstone, Ann Taylor delay tactic will result in suppression and denial of motion for alternate suspects.